Jeff, for that warm intro. We're here today to discuss guest restrictions. So a little bit about our firm before we formally get started. We're 20 attorneys. We all practice in the area of community association law, representing almost exclusively condos and HOAs since the 1990s, as well as co-ops, mobile home parks here and there. 8 of our attorneys are board certified in this practice area. 1 is board certified in construction law. We've got several mediators on staff. Bottom line, if it pertains to a community association in Florida, regardless of location, regardless of what the issue is, we can probably help you out. And we hope that if those types of issues arise and you're not already a client, that you'll reach out to us. We hope even more that if you are a client, you don't just unilaterally decide we're going to handle this without an attorney, because then you end up paying us more to fix it. So we're pleased to present this seminar for your education. Please understand, nothing I say today is going to be legal advice. I don't necessarily represent you or your community, and what I'm trying to do today is give you general information as to how the law works. And as you might know, if you've been involved in any legal issue, there is always an exception to the rule somewhere in case law, a statute, or in your governing documents. And so bottom line, if you need concrete answers to any of the questions you might have, I might be able to give that to you today. But if I'm not, you're always welcome to reach out as an association board of directors and see if we might be able to help you out. So if you ever need representation for your community, hopefully you'll think of us. Again, my name's Alan Schwartzseid. I'm the managing attorney of the firm's Orlando office. So getting started, unless Jeff has something to add with respect to guest restrictions, screening tenants and new owners, is it worthwhile? And as Jeff implied earlier, the answer is obviously yes. The question is, how do we do that? What can we do? What can't we do? And that's some of what we'll get into today. We're going to get hopefully not too into the weeds so that there's plenty of time for question and answer. I've only got a few slides today. I'll spend a little time talking about each one. And then once we're all done with the slides, we can just move over. Jeff, did you have anything you wanted to add before we actually get started with the presentation?
Yeah, just a quick thing. The way you will ask your questions a little bit later. We will enable the Q&A icon at the bottom of your screen right now. I'm not sure if you see it or not. I have it disabled. But once we are nearing the end, I will enable the Q&A function, and that's what Alan will go through a little bit later to answer questions pertinent to this topic. Remember, we cannot get too specific. We do not know your association documents. So it must be a question that is general in nature as it pertains to the legislation and not necessarily to your association. So with that said, Alan, back to you. I'll interrupt you a little bit later when I to let everybody know that we turned on the Q&A.
I'm used to that. That's fine. Just to add, legislation and case law is something that we're able to provide guidance on. Now, keep in mind also, you don't necessarily want to be too specific as to the situation you're talking about, because you never know if the other side is on this webinar as well. Right now, looks like we've got about 185 attendees on. So just be careful with what you ask and how. All right, moving on to the presentation itself. So here's what we're going to discuss today is how to control these individuals, your new owners, your new tenants and guests, whether they need to be registered, etc., before and after they enter your community. Okay, see, we've got 12 slides. We're already done with 2. This will be quick. So if we're going to try and control any behavior, it's not.
We're not seeing your slides. You want me to share the screen?
Oh, I guess that would help. I apologize. Good call. Nice save, my friend.
Anytime.
All right. And you know, we talked earlier about how I'm so prepared to do this, but maybe I'm wrong. All right. Are you seeing now?
You are uber prepared, and yes, we are seeing it. Take it away, sir.
I love being the stereotypical. Can you see it now? Can you hear me now? That's fantastic. You're very welcome for this excellent presentation, everyone. All right, moving back into the presentation, now that you've got the slides in front of you, which you will get after you complete your survey, as I believe Jeff mentioned. So if we're going to talk about controlling any behavior in the community, there needs to be a basis for that control. And I will tell you, there is no basis in the Florida statutes for that level of controlling who can buy, who can lease, and who can be a guest in your community. So you're going to have to look at your governing documents in particular. Now, what those governing documents are is what we outlined here. There's a hierarchy to those governing documents. There are a lot of restrictions that if they're not in the declaration, they're not valid and enforceable. So what rights and restrictions do your governing documents have? We want to look at the governing documents and what they are. The declaration, and I explain this in every board certification class, I'll go through it briefly now so you understand maybe why we say if it's not in the declaration, it may not be enforceable. Okay, your declaration is like your constitution for your community. It's the most important governing document that you'll have. It's going to have most of your covenants in it. And that's what we're looking at today is covenants governing how you can restrict buying, selling, leasing, etc., all of the property, all the lots, the units, or anything in your community. Next, we've got, and when I say next, I mean next in importance and hierarchy is the Articles of Incorporation. This is a document that's generally going to say what your corporation was formed for, whether it's profit or not for profit, hint, hint, probably not for profit if you're a community association, and what the association's scope of responsibility and what you're allowed to do will be. What is the purpose? And in reality, this is a form that's used almost uniformly by every community. Sometimes you'll have some things thrown in that are normally found in your declaration or your bylaws, but chances are this is just going to be the same document that every corporation in the entire state files with the state of Florida, and hopefully it subsequently gets recorded in the county public records of the county where your community is located. Your bylaws are the next document in line, so to speak, and they're generally going to be, okay, well, here's how the community is supposed to operate. What are your directors and officers supposed to be? What are the criteria for having those directors and officers? How are meetings supposed to be run? And then finally, you'll have your your rules and regulations. Those are going to include screening criteria, specific criteria, not just the general right to screen all of these people we're talking about. There are a lot of different things that could go into those rules and regulations, but generally they need to be supported by what's in your declaration. If there's nothing in your declaration that says you can screen or do any of these other things that are listed at the bottom of the screen right now, you probably can't do them. So that's something you'll need to run by your attorney. It may be in your bylaws. That's great. That doesn't mean it's enforceable. I can put whatever I want in rules and regulations. The board can vote on that. Okay, it can say no one of this particular religion is allowed to live in our community. Okay, great. That's in your governing documents. That doesn't mean it's enforceable. So what we want to look at is what are we actually allowed to do under Florida law? So you might have a right of approval, meaning that you get to have documentation sent over to you and say yay or nay as to the individual or individuals that want to purchase this property or rent this property. You might have a right of first refusal that's generally going to give you the right to say, we don't want these people in here, but if we want to actually reject them, we're obligated to send you an alternative purchaser, an alternative tenant. Now, some of those rights of first refusal say that if it doesn't go to the association, all of the members then get the right to substitute a tenant or a buyer at the same reasonable terms that would be offered to the person that was going to buy or lease the property. So that's really generally speaking what a right of first refusal is. You might have screening or background investigation fees. Those are limited generally now under Florida law, but it's going to be, are we going to do a criminal background check? Are we going to look at this person's financial records, which we'll get into later? Okay, all of these things. Do we need a security deposit if we are renting the property? Is there just one for move in and move out, or is there one that the association keeps in case of any damage that this tenant or their guests do to the property? That might not care quite as much about the community as a whole as someone who actually owns property in the community, especially if we're talking about short-term rentals. Okay, now that doesn't mean that someone that's leasing property doesn't care about the unit, the lot, or the community. But it's more likely that someone who doesn't actually own the property is going to let it, you'll excuse me, but go to crap, versus someone who actually owns it and is making a long-term investment in this community and in this property. You have down payment requirements. If someone's going to buy, I've seen where you need to put down a certain amount of dollars or percentage of the purchase price. I don't know how enforceable that is because frankly, it has nothing to do with the overall ability of this individual to pay your assessments, which is really what you care about when it comes to fiscal impact. And then you may require move-in, move-out deposits or security deposits or other types of deposits. There are also construction deposits that I've seen required. So these are all just things that you might want to be aware of that might be in your declaration. If they're not in there, you might want to consider inserting them. And most of, actually all of these things will most likely apply to anyone that is in your community. Some of them we'll get into later might only apply to the people that actually say, yes, I think this is a good idea and vote in favor of it. But generally speaking, most of these particular items will apply across the board. Okay, what transfers are actually subject to approval? Bottom line, look at your governing documents. That's the answer. Okay, if your declaration says that nothing is subject to approval or doesn't insert an approval right or a screening right or anything like that, if your declaration is silent on all these issues, you have zero right to screen. You have zero right to do anything with respect to a transfer other than be informed of the transfer once it's completed. Now, that generally will mean that you probably want to amend your documents to make it clear how that process should be done, who notifies you and when, etc. And that's a bare minimum. Okay, that's just, listen, we need to know who owns the property so that we know where to send notices. That should be done at closing by the closing agent, but that doesn't always happen. Just like the closing agent, I believe, is obligated to provide a copy of the governing documents, they don't always do that. What you may want to do is require that upon any transfer or lease, the governing documents are provided by the owner, not by the association, so that it's not the association's cost, but they're provided by the owner to the buyer, to the tenant, whoever it may be. Moving on to this slide. What transfers are subject to approval? It may be that only arm's length sales are subject to approval. There may be sales or transfers that are not at arm's length. You could have family transferring to family. It could be through a devise, inheritance, a gift. You never know. Sometimes those types of transfers are not actually subject to any restrictions, even though you've got them in your governing documents. Sales involving other consideration, if you're trading one piece of property for another, or an expensive vehicle or whatever it may be, that may or may not be subject based on the way your governing documents are worded. If they say that any consideration is sufficient to require any kind of screening process or anything like that, great. You don't have to worry about what the consideration, what the the sale fee or the lease fee was that's being paid to the former owner or the owner of the property that's leasing the property. But there may be completely different setups of how that transfer goes. There could be transfers by operation of law. Life estate is essentially someone owns the property and they're letting someone else live there in accordance with the deed that actually names both people. And when that person that lives in the property passes away, it automatically, the full ownership transfers to the life estate holder. You can have a trust where there's no one individually who actually owns the property. It's owned by the trust, and the trustee gets to decide what to do with it for the benefit of the beneficiaries of that trust. There could be intestate succession. In other words, someone died, the property went through probate, and it's transferred via what's called a trustee's deed, or it could be just by some other form of transfer. Dissolution or merger of specific corporate entities that were the owner could transfer the property over to somebody else. Could be through foreclosure, in which case most of the time the person that purchases at a foreclosure sale is not going to be subject to the same restrictions as the individual who would go out and purchase it at an arm's length transaction. A lot of these things make sense, and also mortgagee exceptions might apply. This is really to incentivize lenders to actually lend money on properties within your community. If that restriction didn't apply and they had to actually go through the approval process, lenders might not be willing to lend money, because the result of a foreclosure would be they might be stuck with this property for who knows how long and be obligated to maintain it, pay assessments, even though they've got a potential buyer. They want to buy that property and get rid of it as quickly and easily as possible. So they don't want any of those restrictions. Granted, most other people don't either, but lenders, unfortunately, have a little more power than the regular individual, so to speak. You could have restrictions on tenancies, moving back to the slides. You could have restrictions on additional occupants or family members. So it may be that, even though you're allowed to rent, you can only rent with 2 people living there before you have to have additional occupants or family members registered. The other thing you'll look at with respect to guests is, does someone automatically become a tenant under your governing documents, subject to all of these time restrictions and registration restrictions, screening restrictions, if they stay long enough? So a lot of community governing documents will say, well, if you're here for 7 or 14 days or more, you're no longer a guest. Regardless of whether you're family or not, all of a sudden you are treated as a tenant. You are a tenant pursuant to the governing documents, and you're subject to all of the tenancy screening restrictions that are in those governing documents. Some will say, yeah, if you're a family member, you can stay as long as you like, or family members can stay 1 or 2 times a year, up to 6 weeks, whatever it may be. So just bottom line, be aware of what your governing documents actually restrict, and anything that's not restricted, you probably can't control without an amendment to those governing documents. When we talk about guests, there are some community documents that require the owner to actually be present in order for those guests to use any of the amenities. It may be that there's an approved resident, especially in communities where there's a lot of corporate ownership. There are different restrictions that you might have based on whether you're a family member of the owner or just some random guest. The question is, what do you do to try and get people to prove all of this? Oh, well, I'm the sister-in-law of the cousin's boyfriend. Okay, is that a family member? Look in the declaration. If there's a definition of family, great. If there's not, you need to amend to add one, in my opinion. And then you have family versus immediate family. So you've got, like I said, the cousin. Is that a family member under your particular set of governing documents? Or does your definition of family in the governing documents mean immediate family? In other words, it's just, spouses, children, and that's it. Does it encompass siblings? Does it encompass parents, who a lot of times are members of the immediate family, especially in this current climate of, having parents or children move in with you? With grandchildren and grandparents, etc. Or are these people just completely unrelated and they're separate, they're governed by separate restrictions? A lot of this, I know, is not an answer for you, but there are things to be thinking about when you're thinking about how and whether you are able to restrict the way that these people act in your community, whether they're allowed to buy into your community, and whether they're allowed to reside in your community, which is separate from buying. Even if you own property, you may be precluded from living there if you're not compliant with certain restrictions. So, for example, there are a lot of 55 and over communities where you can buy in there, but you can't move in even though you own the property because you're under the age of 55. And they have certain limitations on who can live there and who can't, and percentages, etc. Okay, moving on. So what can we do? If we have the right to screen buyers or tenants, how do we actually do this? Well, the association can report that the transfer or the lease is rejected. Sorry, but no, find somebody else. This isn't going to work for us. Now, all of this needs to be in your documents. You can substitute a proposed transferee. In other words, we have the right of first refusal as an association, but we have the obligation to send someone else to replace the person that was going to buy or lease the property. I found it rare in the past where there is a substitute transferee available by the association that isn't the association itself buying the property. I don't have a problem with that in general. Just be aware, it's in my experience, it's rare that there's someone else out there unless the board has someone in mind that they want to come in and rent or buy in their community. And then you've got general rights of first refusal. Like I described earlier, you're just proposing that someone else within the community or someone else in general purchase the property. Generally, it's going to go to the association, and then it might then go to the membership as a whole. There are probably going to be notice requirements that the owner needs to send notice over to the association, and that if the association doesn't buy it, either the association or the owner, depending on your governing documents, then needs to notify all of the members of the community of their right to propose that they buy it instead or propose a substitute. So keep in mind this, the right of first refusal and substitute are technically separate concepts, but they can play into each other fairly frequently. Okay, what can happen if we reject a transfer or an occupancy? Now, keep in mind, covenants restricting alienation, meaning restricting the right to transfer ownership or transfer the right to use the property, which is a tenancy, are disfavored but allowed under Florida law, even if they're created after you take ownership of your property. They do need to be reasonable, but that reasonableness is completely subjective. So there are cases where the association was even able to limit one rental during the entire time someone owned the property. And what do you need to do there? Of course, you're going to have people that are transferring ownership back and forth fairly frequently, unless you've also got restrictions on how frequently or how and to whom you're able to transfer ownership. So for a while, just understand Florida law was essentially new amendments that impose restrictions on leasing only apply to those who actually vote in favor of the restriction or buy their units or their lots after that amendment's enacted. In other words, you're grandfathered in unless you vote for it or buy after the amendment is in place. That's still a law in a condo. That's 718.110. I think it's 13. Now, as of a few years ago, I think it's 2 years ago, 2021, I believe, in July, there's an HOA restriction that prohibits rental agreements for less than 6 months or rentals more than 3 times per calendar year will apply across the board. Okay, that one's for sure 720.306. So these are statutes that you can look at. Most people will not, but I'm just explaining this is what we're talking about here. Okay, so in other words, in an HOA, it is only if you buy in after or approve the restriction, unless it is for basically saying you need to rent for at least 6 months or you can't rent more than 3 times in a calendar year. This was essentially intended to address some of the short-term rental restrictions that people wanted to put in place, but said, we can't get the vote. It's not going to be valid as to most of the people in the community because they won't vote for it. Now, all of a sudden, at least in an HOA, not in a condo or a co-op, this is going to be valid across the board. Whereas in a condo or a co-op, it's just going to apply to those people that actually signed off and approved the amendment, voted in favor of it, or who purchased their units after that amendment went into effect. Okay, so getting back to the slide itself, for sales and tenancies, you might have that right of first refusal or the right of substitution. Can you even deny a transfer? Okay, the question becomes, if you've got that right of first refusal, what does that mean under your declaration? Because keep in mind, you need to look at the definitions and the way that this is applied under your declaration, not just in general under Florida case law, because Florida case law doesn't say what a right of first refusal is unless your declaration specifies if let's say if the board doesn't have a substitute purchaser, they have to allow this. Okay, it might just say the association has a right of first refusal as to any sales in the community, and then it passes to the members. It might not say, and it should, but it might not say what happens if that right of first refusal is enacted. In other words, the board says, no, we don't want to buy it. And then it goes out to the members. Chances are at that point, if no one comes back and says in the proper manner under the declaration, I want to buy it, or I propose this substitute, depending on what you're allowed to do under the declaration, that person's going to be allowed to just go ahead and sell it to whoever they want that was proposed initially. Okay. Grounds for disapproval. You've got good cause determinations of why you can say, well, we've gone through our screening process and we don't think this is a good person we want in our community. That could be based on financial issues. That could be based on criminal violations, things of that nature, which we'll get into in a minute. The question is, do they facially qualify as members of the community? If the answer is yes, chances are they're going to be allowed to buy in or rent. Your declaration should say who can and can't live there. Chances are it's not going to have any restrictions on who is allowed to live there. Okay, you might have restrictions on how certain people need to cooperate with the community, how they need to act within the community. But most communities, unless you have these restrictions and then established separately, almost always it's a separate set of criteria that is established by the board but is authorized in the governing documents. Okay, that's it. It's almost always going to be the declaration says you can apply criteria and then the board selects what they are. Unless you have that type of criteria and that authorization in the declaration, chances are you're not going to be able to restrict who moves into your community. So that's something you might want to consider amending if you don't already have the right to do. With respect to gifts, divides, and inheritances, when do you evaluate the transfer? Okay, it's usually going to be after the fact, because these people that are ending up with the property don't know a lot of times that they're going to end up with it or when they're going to end up with it until after they actually have either a court order or they found out all of a sudden, oh, I'm the owner. Now, when it comes to some of these automatic devices under operation of law, you might have some control there. So what I mean by that is, if a property is owned as joint tenants with right to survivorship, that's a method of ownership of real property. That basically means is that it means that if you have 5 owners of the property and they all own as joint tenants with right to survivorship, one of them dies. Well, now all of a sudden the other 4 own it. That's it. Instead of owning a 1/5 share in the property, now they own a 1/4 share. And as each individual passes away, it ends up with the last one. Okay, this is an automatic under operation of law type of thing. Same thing with tenancies by the entirety. When you are married and you own property as husband and wife, okay, as long as there's no divorce that intervenes, if the husband dies, it goes to the wife. If the wife dies, it goes to the husband. Obviously, there are same-sex marriages that might, I won't say complicate that, but might go husband or whatever you want to call it. But bottom line, all of these transfers from one to the other that are automatic are generally not going to be things that the association gets to restrict, unless the governing documents say you get to control even who the let's say it's a situation of someone passing away and automatically transfers to another person. There you might get to control who that remainder person is, but it's not guaranteed unless it's in your governing documents. Okay, you're almost always, if you are saying no, you can't do this, you're almost always, in other words, you can't rent to this person, you can't sell the property to this person. The governing documents should and almost always will require the association to make that person whole. Okay, well, how do we determine the sales price? How does the association designate a substitute? These are all things that you want to run through with your counsel. Is it a first come, first serve owner option? Or is there a specific designation that the association needs to make of, like I said earlier, well, we named this person to take over that lease. And then you've got, again, ownership without occupancy. Like I said earlier, with respect to that 55 and over situation, there are plenty of others that might apply to. So just keep in mind, you've got all of these issues that might come up. You'll want to evaluate your declaration to see what rights and restrictions actually apply. If it's only in your rules and regulations, you might not be able to enforce it, or at least it might not be properly enforced. And at best, the owner who is challenging this will likely have a defense to fight against the association trying to enforce it. Because your declaration, or at least one of your other governing documents that isn't just a board-made rule, needs to support these types of restrictions. Where can we have potential liability as a community association? Well, you could have discrimination. The Fair Housing Act includes protected classes such as race, sex, etc. There are local versions of this as well in counties and in cities throughout Florida, especially in Orlando, Osceola County, most counties and cities in South Florida, and I know there are some in Tallahassee as well. These are all going to require that you ensure there's no disparate impact, meaning that certain classes are not inadvertently even treated differently from others. So in other words, if we're talking about, the type of family that's coming in, whether or not the individuals have children, a lot of times these are not things that the association is allowed to base its opinions of who can and can't buy or lease in your community can be. Another few we've got in Broward and Miami-Dade, we mentioned gender identity, sexual orientation, marital status. There's disability accommodations and modifications that the association may also be required to provide. In other words, someone suffers from a disability. They might be blind, they might have mental incapacity to some extent. The association may be obligated to allow them to rent, even though otherwise they might not be allowed to, or you might need to actually change your property so that they can have the same use of your property, your community, common elements, common areas as everyone else in the community. Now, you're not necessarily going to need to provide someone with no legs the ability to play tennis in your community, for example, but you are going to have to potentially change so that that person that has a wheelchair has direct access. Hopefully, you've got that access to your clubhouse and all your other amenities already set up pursuant to applicable building codes, but you might need to go above and beyond. Now, that cost of putting that in the position where these people can do what they need to do to properly use their community might be a cost that that owner has to bear. But these are things you're going to want to run by your counsel if they come up. If someone requests an accommodation, they don't have to use the words accommodation or modification. They just have to mention, I have a disability, and as a result, I need X. Or you need to know that they have a disability, and as a result, they need X. My suggestion, if you need more information on those types of topics, we do a Fair Housing Act and Pets class that is available on our website. All of our past recorded classes are also available on kvrlegal.com under the resources tab. So you might want to check that out if you need more information about this particular issue, or just contact me. My email is as@kvrlegal.com. We've also got new guidelines, and I say new, they're about 3 years old now, regarding reliance on criminal background checks, which does result or has a tendency to result in a disparate impact against minorities. In other words, relying on a criminal background check has a larger likelihood, according to statistics that the federal government has gathered, to result in a negative reaction to a minority than to someone who is a white male. So using those criminal background checks could result in a disparate impact, and as a result could result in a discrimination claim. So you want to be very, very careful using those criminal background checks as the basis to decline someone for potential ownership or tenancy in your community. Keep in mind, a conviction, I don't even know what that means. A conviction alone is not sufficient to say you can't live here. Okay, that's not going to be a good enough reason. It needs to be based on a risk of safety of people or property in your community. So it needs to be something where someone injured someone else and was convicted of it, or they stole a bunch of money and embezzled money from their last community. It needs to be something of that nature. We're not talking about just, I hid evidence or something like that. Jeff, did you have something to add? I know you like to interrupt sometimes.
Just sounds like you need a glass of water, with your collection thing. So have a sip of water, and I'll just want to mention, I'm going to turn on the Q&A, and you can go ahead and start asking your questions in the Q&A section. And towards the end, Alan will start answering pertinent questions to the topic. And then, but before we begin the Q&A a little bit later, I'll once more go over the link for the evaluation and how to get your slides, because for CE credit, you don't need to stay for the Q&A, although we hope you do. Back to you, sir.
All right, thanks for the water break.
You got it.
So another point, we've mentioned the criminal background checks. We also talk about the credit background checks. Use of a consumer credit report requires certain disclosures and notifications to the person. Those will generally be in the form that they need to fill out in order to apply to be an owner or whatever it may be, a tenant. And then there are human rights ordinances in Broward and Miami-Dade County and also elsewhere in the state that you have to notify anyone that you are considering any of these factors that they have certain rights, and that's generally going to be under the FHA that I mentioned earlier, as well as the Americans with Disabilities Act in some instances. And so you'll want to be really cognizant. What I always suggest is, if you've got these potential credit reports and criminal background checks that are going to be used for the purpose of determining who gets to live in your community, who gets to own in your community. Make sure that it's going to be something that is run by your attorney and that they give you some general guidance. It's just a matter of, you want to understand what you're supposed to be evaluating and what you're going to get yourself in trouble by evaluating. So I always recommend that you have your attorney take a look at your procedures for evaluating these applications. Okay, guest occupancy. So you've got some terms that'll be in your declaration. Are guests automatically tenants if they stay too long? What proof do you need to provide in order to demonstrate a family relationship? Does it need to be disclosed on the initial application, or can it be disclosed later? Can they turn into just a guest, or what? How do we do it? And then you've got non-related guests. Are they treated differently from family, or are they treated exactly the same regardless of that family relationship? You've also got occupancy limitations. You might have a number of permitted occupancies, in other words, a number of rentals per year, or a number of guest events by non-owners. You might have a duration of a permitted occupancy. If you're there more than 14 days, you got to get out, or you're automatically deemed a tenant, etc. You might have registration requirements, whether for long-term guests, short-term guests, overnight guests, just depends. And then for non-overnight guests, someone that's just showing up for the day, do you need to be there with them as the owner of the property in order for them to be able to use your pool or your gym? Are they allowed to use the pool or the gym at all? Generally, probably yes, but do they need to have someone with a key card or with some identification as an owner? I know we've got some communities that require some kind of wristband or a key or something of that nature. Are you allowed to just hand that over to someone else so that they can use your amenities on that day? Those are all questions that you're going to want to look at your declaration and see what the answers are. If the answers are not there, you're going to want to try and amend your declaration so that they are there and you're properly governing what people can and can't do in your community. All right, we've got some practical considerations. Remember, I mentioned earlier, covenants restricting alienation are disfavored, but they're allowed if they're reasonable. Reasonable is a very subjective term, again, but there are restrictions in Florida case law on how much you can control and how much you can't. So we've got surveys from members and residents that will dictate what amendments the board wants. It's not just what that 3 to 5 member board wants. It's, well, what does the community as a whole want? If you're sitting there in Kissimmee in a rental community that all, basically feeds into the theme parks, you probably don't want to put a short-term rental restriction in place. That's probably what people bought these lots for, or these units. So you might want to let it be something that everyone's allowed to rent and that you don't necessarily need the control for. If you're sitting in, Oviedo, for example, in Central Florida, it's a small town feel for the most part. And other than wanting to allow rentals for UCF, which is right down the road, you might not want those short-term rentals. You might want only long-term. Other restrictions you can put in place is you have to live there or own the property for a year or two before you can rent. You might need to go through some of these controls before you're allowed to rent or sell your unit or your lot, etc. You might also have to renew your lease and have the association reapprove. Most of the time, it should say, nope, not a problem. But here's the thing. If the tenant creates a problem and your lease renewals are automatic, as to the association at least, then you've got no right to say, nope, you can't rent to this person again because they caused problems before. So you'll want that restriction in your governing documents saying, yeah, they caused way too many problems that we sent out 15 violation letters during the last year because of what this tenant did. You can't have them lease here for another year. You might also put in your governing documents that the association has the ability to evict or remove all of these tenants if they cause problems and violate the declaration in certain ways or in any way. You might have tenants or guests that hold over. Does the association get to order the owners of that property to have these people removed? Or are you taking the place of a landlord in that case? You want to have your declaration clarify these issues. Can you screen additional occupants or just whether or not someone's allowed to rent in general? That'll be in your declaration. Are these people allowed to use the facilities and the common elements? Generally speaking, that right transfers to the tenants. But what if it's just a guest? What if it's someone that is there on a short-term basis? Do the owners now have the right to use it and also to let the short-term tenants in? Well, hopefully not. But if your governing documents don't dictate that, the answer is, yeah, everyone can use it. You might also have issues with access control that you want to put in place. Vehicle registrations might be required so that you know who's causing damage to your gate, causing damage, speeding through the neighborhood. You might have key cards or fob systems either at the gate or at your front door or at a lot of the amenities. I know a lot of people close off their pool or close off their gym or their tennis courts, and you just put in a key card, you put in your fob, and all of a sudden you can get in. Well, how do you activate those things if you don't know who is supposed to be using it? So all of these things are things that you'll want to consider in implementing some kind of policy within your declaration of who gets to rent, who gets to buy, and how does that happen? What does the association get to control? Now, when we've got issues with enforcement, tenants can actually be another source of recovery or curative action. In other words, you send the demand out to the owner, you also send it to the tenant who's actually the one violating the restrictions. Okay, you might have guests or additional occupants that might send you to litigation or arbitration. In a condo, just understand we're now allowed to go to mediation regardless of whether it's a condo or HOA on those use restriction issues. My suggestion is always going to be go to mediation. If that doesn't work or if the owner doesn't respond, you get to file your lawsuit immediately rather than waiting for an arbitrator to make a decision, which can technically be literally arbitrary if the arbitrator decides that they want to be. So there's very little consistency in how arbitrators are ruling on those issues. And when I say those issues, again, I mean your use restrictions. Do you have the ability to evict a tenant or a guest or an additional occupant as an agent of the owner or as a third-party beneficiary of the lease? Do your governing documents automatically incorporate your governing documents and the restrictions in those documents into every lease in the community, which I recommend? Okay, in other words, you can enforce directly against the tenants as part of enforcing the lease. Do your governing documents require that a lease be provided to the association or a copy of the lease, either before or after it gets entered? Okay. Can you deny the use of common elements? In other words, you suspend the use rights of that lot or unit. Do you have that ability or not? It might need to be in your governing documents, especially in a condo. I don't think it does, but some people will argue that it does. Do you have the ability to tow or immobilize vehicles in your community that are either not approved or that are being parked improperly, etc.? Okay, you might have non-approved title transfers. Can you cure the initial defect by basically saying, all right, well, we'll submit all this stuff after the fact that we were supposed to submit in order to be able to sell this property? Do you have a required minimum down payment? I don't know that I like that requirement because it has nothing to do with the association, but some communities do. Are there application procedures that need to be fulfilled? Did this individual complete those procedures? And if the answer to any of this is no, they do have to do this stuff, but they didn't do one or more of those things, is the transfer, in other words, the sale, void, meaning that it's like it never happened? Or is it voidable? And when it's void, it can create even bigger issues because now you have a question of who owns this property because they were supposed to do XYZ. They didn't do XYZ. How do we go back and go after these people? Do you deny access to the property if the transaction is void because this purchaser is not a purchaser under a void transaction? Do we say you don't have the right to enter our community? Or do we say you don't have the right to use common elements? And then we get into recovering the costs, damages, and attorney's fees associated with all of this. Generally, the association is going to have a right to recover attorney's fees and costs, but not excessive or unnecessary attorney's fees, even if they've been incurred. So there was a case in 2000, Sagara, where the association was too quick to file suit. There was $785 awarded towards a $5,000 attorney's fee. Owners and tenants can be sued for failure to maintain the property, or the association might consider self-help, meaning you go out and do the work yourself and charge that to the owner. because the tenant in reality is probably not going to do the work. They're going to send your demand letters, your violation letters over to the owner and say, you take care of this. Where do we send statutory notices? Is the owner designated a mailing address? So these are all things to consider when you're trying to figure out how to do the enforcement. Do we enforce against the owner, the tenant, or both? Okay, and in conclusion, you need to look at your declaration, confirm what you can do and what you can't with respect to these transactions. If you don't have the authority, do you want to try and create it via an amendment to the declaration? You want to establish procedures and proper documentation that's generally done by the board, and it's going to be recorded in your official records by a resolution of the board that says we are establishing these protocols for when someone wants to buy, sell, or lease their property in accordance with the declaration. Again, any rule or regulation that is not supported by or is contradicted by the declaration is probably invalid and unenforceable. Okay, you want to act uniformly and consistently in evaluating whether or not all of these individuals throughout your community can sell or can lease their property. And then again, you want a resolution delegating the authority to a screening committee or an individual board member so that you don't have to hold a board meeting every single time someone wants to sell or lease their property. So it looks like Barbara Holden just asked that exact question a little while ago. That's been answered. So I will say that that one's answered live. Yeah, you can delegate the authority, but only if the board has actually done that at an open board meeting. So you got to do it the right way once, and then you don't have to do it again. Now, if that individual was a director and ends up resigning or coming off the board in some other way, keep in mind, you'll have to have another board meeting to delegate someone new. If it's a screening committee that you're establishing, that committee is also going to need to have meetings. So it just depends what your governing documents require, whether that's a committee that needs to be established, or if it can just be an individual director who gets to review these pursuant to specific criteria and just go ahead and rule on it. And understand the extent and purpose of the restrictions you have in place. What are they there for? Are they intended to keep people out or keep people satisfied and allow people to try and sell their properties while protecting your community? So again, I know I went for almost an hour, but that's all we've got today. I hope you found that informative. Jeff, I know we'll get started in just a moment on the Q&A. It looks like we've got a bunch of questions already. And so if you want to go ahead and get started, I will close out the slides, but my information is right here, as@kdrlegal.com. You can reach any of our offices at 954-928-0680. Jeff, if you don't mind posting that up either in the chat or wherever it's appropriate. But all that information is on the slides that you can get as soon as you complete your survey, which I'm sure Jeff will talk about in just a moment. I'm going to stop sharing and I will shut up for just a moment.
Have some more water. We don't want any more collections, happening.
To do that. No collections allowed, folks.
So real quick, while we welcome everybody to stay, and we hope you do, CAMs are not required to, we know you're all swamped and busy. You don't need to stay for the Q&A if you don't want. You've taken the course. You will get your credit. We will upload the credit. In the chat area, we placed a link for the evaluation. Click on that link in the chat area. It takes you to this screen here. Okay. Go ahead and fill it out. After you hit the submit button, you will get a confirmation screen that looks like this. Now, this is not one of those courses where board members are required to print out and save certificates. You don't need to do that. But if you want to, this is where you can do it. You can click this down here and it'll, if you have Acrobat installed, you can save it as a PDF, or you can send it to your printer and hit print, take a photograph of it with your smartphone, whatever you want to do. But the other thing that you can do, which is why it's another great reason to fill out your evaluation. A lot of you in the Q&A during the presentation were asking about how to print today's slides. On this confirmation screen, about 2/3 of the way down, it says click here to download and save today's slides. So you click the click here button, the slides will open up, and then you can use the little arrow at the top on your browser to download and to save them and keep them. We'll go over this once again after the Q&A. I'll go over it one more time. So for right now, Alan, I will turn it back over to you. And I think we advertised till 3:15, so I think we'll have enough time to answer all these questions. You want to go ahead and take the first one?
Sure. Let's see. So are restrictions allowed against convicted pedophiles or sex offenders in a community? That's actually one of the more popular amendments that I used to do. It is a restriction. It doesn't necessarily say you can't live there, but it might. So are they allowed? Yes, but will any individual judge uphold that? Somewhat questionable. I think that based on the way that that amendment tends to be drafted, with some of the background behind why the board is putting it in place for the safety and welfare of the community as a whole, that might be something that a judge would likely be willing to enforce, in my experience. Fortunately, I have not had anyone challenge that. People tend to just say, I don't want my affairs to be made even more public than me having already been listed on a sex offender registry. And by the way, when I say me, I don't mean me in person. I mean the individual we're talking about. I am not on any of those registries, or at least I don't belong on any that I know of. But bottom line, yes, I think that would probably be enforceable based on the way that we would draft it. Whether another law firm would draft it in a way that would show a judge this is really something you should uphold, I couldn't speak to that, which is why I would always suggest you reach out to us directly if that's something that your community is considering. Next one, are we allowed to deny per low credit score, which is in the requirement for everyone who wants to buy in the association? This one is a tough one, because the bottom line is, I don't know why you'd care that the association has someone in the community that's just residing there and doesn't have a fiscal obligation to the association that has a low credit score. I would most likely want to see more than just the low credit score as the basis for this. Now, keep in mind also, when we're talking low credit score, you are also risking that disparate impact analysis. You're talking about, well, certain groups of people may not have as good of a credit score, even though they've got millions of dollars in the bank. So that's why I suggest don't ever rely exclusively on a credit score. If someone's got the money to pay, they're going to pay. A tenant is not obligated to pay. Now, if we're talking about a buyer, I know that that's what the question asked. If we're talking about a buyer, yes, that might be some criteria to consider, but I would be more likely to consider the credit score and additional financial criteria. I think a low credit score, someone could have $8 million in the bank and never need credit, so they don't use a credit card. They don't have a loan on their previous home. They don't have a loan on their car because they paid cash for everything.
Alan, before you go to the next question,
yeah,
a few people have asked in the Q&A, will this seminar be available on video for replay within a day or two, typically within a day, but I like to allow a couple of days on kbrlegal.com. Yes, it will be there. Once you go to the website, go to the resources tab on the menu at the top, and then the submenu webinars and videos. And that's where it will appear at some point tomorrow or the day after.
Okay, we've got one that's in the chat. Please keep all of this in the Q&A section, by the way.
I just turned off the chat after I saw that.
Got it. I'll address it just so that I don't have to try and remember to go back to it now that I've seen it. Have you ever heard of 55 and over community with a 19-year-old minimum instead of 18? I've heard of it. Whether it matters, frankly, I don't know. I'm not aware of anything that prohibits having a 19-year-old minimum, but that's something that you'll want to run by your attorney and have them evaluate the requirements of a 55 and over community. It's not something that's necessarily going to be in Florida case law. It's going to be in the 55 and over requirements, which I believe are federal. Moving on, Gary Edler asks, could a convicted felon for stalking and restraining orders serious enough for refusal? In other words, can we refuse a potential tenant or occupant or owner based on a stalking conviction? And this is a convicted felon. Now, keep in mind, some of the things that we mentioned are criminal. We want to make sure that all these things are recent enough that they're actually relevant to the occupancy. If this conviction is 15 years old and there's been no criminal violation since then, I don't think that it's going to be relevant. It may even be a murder conviction from 20 years ago that's no longer relevant. So, Jeff, I think you closed out the Q&A. You're going to have to go through these from now on because I can't see them anymore.
I did because we're getting to the point now where we're not going to have enough time to answer all of them if we leave it open. So David asks, what steps are we able to take to limit rentals in our condominium community? So I guess assuming what legislation says and not regarding whatever David's documents say.
Right. So, I mean, your governing documents really are going to dictate that. But the bottom line is there are tons of restrictions that could be put in place. You just have to amend the governing documents and specifically, generally, the declaration if you don't already have those restrictions in your declaration. I mean, the answer is it's almost limitless other than what Florida case law says you can't have or federal case law says you can't have. In other words, like I said, you can't have something in there that says no Jews can own property in our community. That is under Florida law and federal law is unenforceable. So anything that's discriminatory is not allowed, but anything else for the most part, you can do an amendment and that's something that we do every day. You can do an amendment that will restrict how or whether someone is allowed to lease, sell, or reside in a unit or a lot in your community. Jeff?
Everything else is pretty much fair game as long as it's not discriminatory.
Right.
In a nutshell. Yeah. Okay. Amir asks if guests are allowed for 29 days. I guess this is specific, but you'll see it's a general question in a way. If guests are allowed for 29 days in the bylaws and then leave for a month, are they allowed to, in your experience, are they allowed to come back for an additional 29 days?
That depends on how the declaration is worded in particular, because if it just says they can only stay for 29 days, they could leave for a day or they could leave for 2 hours, come back and still not be deemed to be part of that 29-day continuum.
So what's missing there is the word consecutive in their bylaws.
You've got consecutive, and you've also got whether or not it says once they have exceeded that 29 days, they can't come back for X amount of time. If that's not in there, then leaving, being there for 29 consecutive days, leaving even for, I would say 24 hours is probably sufficient. And then coming back is not something you can restrict. They'll be allowed to stay for another 29 consecutive days. So you'll want to amend the declaration to clarify that issue if it's not already clear.
And that's something KBO, that's something we can do. We can help out with.
That's something I do probably a couple times a week.
Yeah. Yeah, that's definitely not a unique situation, Amir. Okay. Michelle asks, criminal convictions. How about prior drug convictions and multiple speeding incidents and DUIs? Is that something that would that be considered discriminatory? Is that something that could fall into that category?
It could, and especially when you're using those specific violations, those specific crimes, I don't anticipate that it's going to be sufficient to be something that impacts the safety of the community sufficiently that it would be a justification in and of itself to say, no, you can't reside here or you can't buy or lease here. I have a feeling that would be something that you'd have to have something else in conjunction with those types of crimes. Additionally, like I mentioned earlier, whenever we're talking about crimes as the basis to deny a purchase, a tenancy, whatever, you want to make sure that it's relevant to the association, the safety and welfare of the people, the property, but also that it's recent enough that it actually matters. Someone might have been in a really bad place 10 years ago because they lost their dad or something similar. And now all of a sudden they've, I don't want to say gotten over it, but they've moved past that stage of their life and they're trying to clean everything up. They've done everything right for the last decade. That's generally not going to be something that we're going to use as a criterion to say, sorry, but I know you've cleaned up, but too late, too bad, so sad. Okay.
This next question from Charlene is similar to the question that we had a couple of classes ago about weed. If it's like illegal in the state, but legal in the city, but different topic here. So in an association, if the declaration the final word or the bylaws, if the bylaws are less restrictive, meaning, and I'll do my best to decipher what she wrote here. It's kind of a broken sentence. If the declaration says no leasing or guest occupancy restrictions, but the bylaws gives a leasing clause that allows leasing in specific conditions or allows guests, but if over a certain day becomes a permanent resident. So I hope that made sense. What is the final rule? What would hold?
I mean, bottom line, we went through the order of importance. That is also going to be the order of control.
True.
Anything that is in the declaration is going to control over anything that's in the bylaws. What you'll want to look at is the specific provisions we're talking about and determine, does this actually conflict? So is the declaration actually saying no one can lease in this community, and the bylaws say, but you can lease if? Well, if that's the case, then the declaration controls. I don't care what's in the bylaws, you can't rent.
Okay. So this person, Cheryl, says, I believe you alluded to this question earlier. If it's repetition, apologies here. Our condo board is in the process of voting on an amendment to our corporate docs to increase the duration of the rental minimum.
Okay.
We stumbled across Florida statute section 718.110.13, which appears to grandfather the current owners who vote against the amendment and allow them to continue rentals at the current duration. Is this a correct interpretation? And is there a way that the condo board can restrict the rentals of all owners, regardless of vote? And again, I believe you alluded to this earlier.
Yeah, I mean, I pretty much covered it. In a condo, there is no across the board when it comes to rental restrictions.
Okay.
You're going to be, you voted in favor of it or you bought in after. Anyone that doesn't do either one of those, sorry, but you're just out of luck.
Okay. And if some of these that I read are repetitious, Alan, just don't be afraid to say, Jeff, I read that already, you jerks, move on. So hello, I'm John. We have residents a resident's son who now lives in their home. However, that son has moved in some unregistered people who are renting. This is interesting. That son has moved in, has, I guess, allowed other unregistered people who are renting rooms in that home. That's hard to prove. Should we file a case? Is this something you think we should file a case against? The owners are out of the country anyway. I guess looking for a little opinion there. What should they do?
I mean, it really depends on what your declaration says. Do you have the right to restrict rentals in general? Do you have the right to restrict who gets to rent? If the answer is yes, and they're not complying with it, I don't care where the owners are located other than for purposes of serving them with process in that lawsuit. But the first thing I would do is send out, this is a type of thing where I would suggest pursuing it at least through the offer for pre-suit mediation stage, if your declaration would support a violation. And if it gets through that stage and you haven't gotten any curative action, you haven't gotten any response from the owners, you've sent them emails, hopefully you have their email addresses with copies of the violation notices. And be aware also, most communities will have 1, 2, or 3 violation letters that go out before this even reaches an attorney. So you can email them and say, hey, I see this is going on. Do you intend to do anything about it? Because it's in violation of section whatever of the declaration. And if you don't do something about it by a certain date, we're going to be starting to send these notices, and eventually this will be sent to council. I don't see any reason, if this is a violation, why you wouldn't want to take it at least to the stage of offering pre-suit mediation and then making a determination of whether to file a lawsuit. But that's something that I would suggest discussing with your actual attorney and getting a full legal opinion on whether this is a violation, what you should be doing, etc. If you don't have an attorney and that's why you're asking me, feel welcome to reach out and we can change that.
Yeah, I can recommend a few good ones. Okay, this one is I know we said to keep the question general, but my gosh. What if they lied when they were approved? And that's all it says. So I'm guessing you approved. I'm guessing this person means the association approved somebody, but then you later found out that there were a bunch of lies on the application.
Make sure that your declaration actually says that any false information included in the application process will be deemed to void and waive any right to live or buy into the community. The problem that you'll have is, if we're talking about a transaction that was approved by the association, is that voidable, meaning that the association gets to go back to court and say, well, we want to undo this transaction. And also, what benefit does that bring to the association unless this person really is problematic and shouldn't be in the community?
Okay. We have about 8 minutes left on advertised time with about 8 questions left. So I guess this will be a little bit more of a rapid fire if possible. Gina asks, I missed part of the information for leasing in an HOA. Has it been changed in the statutes to 6 months?
So the change came in about 2 years ago, I believe, and it essentially is the same as a condo with the addition. In other words, it's only people that bought in after the restriction went into effect, or who agreed to vote in favor of the restriction and did vote in favor of the restriction. In an HOA, the distinction is that there are a couple different criteria that were added in a couple years ago in the statute. One is if the lease is 6 months or less, the association can say that's not allowed. Or if you are leasing more than 3 times in a calendar year, the association can say that's not allowed. Those 2 types of restrictions will apply across the board.
Okay. So this is an interesting one that may have been touched upon, but is common. Shelley is asking, may a short-term renter, sorry about those text noises, let me turn that off. May a short-term renter be treated differently than a long-term renter? Example, limiting the use of common elements or the use of a marina, so on and so forth.
Probably not. I'm not aware of anything that says you can't, but I can imagine if
You're asking for trouble.
yeah, but I can anticipate if you're allowing short-term rentals, then treating short-term renters differently than long-term renters could be or differently than any other member of the community that actually resides there could be problematic. You're basically, by allowing short-term rentals, you're saying people are allowed to do this. So to hold them to a different standard or treat them differently, there are certain things you might be able to control, but I don't think that access to amenities and things like that being different is something that a judge would be okay with. When you're asking these questions, one thing that you always have to keep in mind is, what is a judge going to say when we try and enforce this? Is a judge going to say that this is a reasonable restriction or that it's completely absurd? Now, if it's in the declaration and the owners agree to it because they vote on it and you've amended to include that, you know what? There's a lot more likelihood that a judge is going to say, well, everyone wanted it. Sucks for you guys. You know, the few people that didn't. But, you know, if you're just talking about rules and regulations, I absolutely would not suggest putting that type of restriction into your rules and regs. It would have to be something, in my opinion, at a minimum that is in your declaration.
Same here. Putting my former manager's hat on, that's something I would advise the board, do not do it. You're just asking for trouble you don't want to deal with, future attorney counsel expenses, the whole 9 yards. But
when I say, you know, it may not be enforceable, I also want you to keep in mind that just putting that restriction in place without trying to enforce it could subject you to a lawsuit for declaratory relief, where someone's asking a judge to say it's invalid, even though they're not trying to use that type of short-term rental amenity use.
Yeah. I'm not sure what this one means. Can an owner bring a paying roommate while he still lives in the property? I don't know. We're going to skip that one.
You have restrictions on whether or not you can rent out an individual room or a portion of a lot or a unit. That's what you're going to look for in your governing documents. If that's not there, then you probably can't control it. You may be able to control whether that individual is allowed to move in if you've got those screening requirements for occupancy.
And if the community doesn't say anything about it, that's something that the owner of the unit can say, hey, you're not allowed to rent it. If I'm renting to you, you're not allowed to sub-rent to anybody else.
Right. That would be a term of the lease, though, rather than a term that, frankly, I care about.
Yeah. Let's see. Barbara asks, regarding the delegation to a board member to approve sales and leases without having to do it at an open board meeting, can the delegation be made to the president so that the delegation can be memorialized in the minutes and separate resolution for future presidents?
Yes, but I think the better way to do it is to amend the bylaws to make that clear and put something in there that is one of the obligations of the president, so that it is truly a permanent situation rather than just well, we think this is good enough going forward. I think it probably is, but my opinion would be that if the members approve that, it's really not subject to questioning.
Okay. There's about 3 minutes left with 5 questions. You want to go for it?
Let's go for it. Let's see what we can do.
All right. Anne Marie asks, prospective owner has a perfect credit and criminal record, yet the interviewer falsely believes that the prospective did something illegal. Guessing games here. This is just rumors and innuendo. You said the prospective cannot be refused unless they are a safety risk. What state statute refers to this that you're aware of?
Case law, and it's general case law in Florida that, and frankly, federally, that you need to have an actual basis to say someone's not allowed to live there. It's the case that I mentioned earlier. There are numerous cases that say Florida hates, and when I say hates, I mean the court system hates controlling what people are allowed to do with their property. The only reason that we can restrict this at all is because they've already agreed to be a part of an HOA or a condo. And so this needs to be very clearly stated. And if you're talking about someone having the inference or guessing game saying, well, I think that they did something wrong, prove it. Because if you can't prove it, then you don't have a basis to restrict this and say, you can't live here. Sorry, but a bad feeling is generally not going to be enough to say, nope, can't live here. Owner, you need to find somebody else to sell to.
They'll also have rumors and conspiracy theories get started. That's not a good thing in an association environment.
Right. You want to be uniform across the board in how you deal with these things. And when you're being completely subjective and saying, I think they did something wrong, that's where you lose your uniformity and you end up with selective enforcement defenses to any of these enforcement efforts. Jeff?
You know, it could also affect your credibility as a board member. You know, that's something to think about if you want to run for re-election. You know, Vicky asks, we see it often where an owner, and end quote, lends their homes. I feel like the SNL character lends their home to a friend for 30 days, but the friend lets it slip that they are paying rent for the time. What is the best way to handle this? Not all guests let that information slip out.
If you're aware of it and it's restricted and something that's not allowed under your governing documents, treat it as a violation of your covenants and move forward. Done. Just like any other violation.
Let me see, this might be similar. Can the association enforce an overstaying, I guess, if the owner died? But it's because of, okay, can the association enforce an overstaying, can the association enforce on overstaying guests if the owner does their screening as required, just because they do not want them to stay more than the stated guest period?
Depends on the declaration. If the declaration says you can only stay 30 days and they're there for 31 days, again, covenant enforcement process, move forward with it. That's it.
Yeah, I mean, there is a way, I guess somebody could be reasonable if there's an extenuating circumstance, a car breaks down and they're supposed to drive off that day. I mean, if I get there's a valid reason to explain to the board, right?
I agree, but that's you just hit the nail on the head. You explain to the board. You don't just stick around for as long as you need to.
Exactly.
And if people don't reach out to the board and get the violation notice and say, what's wrong with you people? I had car trouble. I couldn't get out of here. That's when I have a problem with the response. If you have a problem and you need an accommodation of the association's rules, send out a request to actually be allowed to violate the rules. Otherwise, you're just in violation, whether you had good reason or not.
Yeah. Okay, our last question here. Actually, there's two, but this one may not be pertinent. Jose asks, in our community, there's a case where a unit is under an LLC and have members that are real persons and another corporation that hides other people. Those members on the second layer corporation or the LLC are entitled to be owners with access to, okay, it wasn't formed in as a question. Are those members on the second layer corporation or LLC entitled to be owners with access to the amenities?
I mean, anyone that is included in that LLC might be entitled to do it. It just depends whether you're required under your governing documents to have a designated member who is living there under the one or the other LLC. So if it says, a corporate owner has the same rights as an individual, or it doesn't say anything, yeah, I mean, anyone can use that has anything to do with the LLC. So it just depends on your documents in that case. And if the individual is not entitled to use it, go ahead with your enforcement. If the individual under your declaration is authorized to use the property, they're authorized to use the property, no more to do.
Perfect. Thank you, Alan. And Pete, you had a question that was unrelated. This might be a yes or no answer. This is the last question here. Can the association tow an unregistered vehicle, and is it necessary to be in the documents? That's not really pertinent to the topic here.
Generally, answers are yes and no. The association will generally have that right, but you need to put up signage. There's a lot of other things that we can't go into right now that you need to do before you can properly tow a vehicle from your community.
There you go. We got through all the questions. We only went a couple of minutes over. Alan, I'm going to stay on and go over the evaluation one more time. But before I do that, any parting words and the best way for everybody to reach you, even though Alan's information will be on the follow-up email and the slides that you can download, which I'll go over one more time. But Alan, parting words, sir.
Just I appreciate everyone's time today. I hope you all got a lot out of the class as well as the Q&A session for those of you who stuck around. I always welcome you in that survey. There's going to be a check mark that you can do that says I'd like to be contacted. I will contact every single person who clicks that box personally within the next week or so. So if you would like to speak with me directly, whether that's about becoming a client of our firm or just any particular legal issues that you have that you want to discuss, I welcome you to click that box, and Jeff will get me all the survey results within the next few days, and I'll get out to you probably either Friday or Monday of this week or next week. So without further ado, thank you all. Thank you, Jeff, as always, for serving as an excellent moderator. Appreciate your help, and y'all have a great day.
Alan, thank you. Same for you. I know you're swamped. Get to it, and talk with you soon, buddy.
Looking forward to it.